Hi equals, it's Kim, and we're back in my car for a minute for equality in the car. Anyway, if you're new here, my channel is Kim Perfect TV, where I talk about LGBT issues. Lately, we've been talking about Title VII and the cases before the U.S. Supreme Court. If you like this type of video, please give me a thumbs up, hit the red subscribe button, hit the bell to be notified every time I put up a new video. It would help me out a lot. Thank you. Anyway, today, and I'll link the others in this series on Title VII. So the U.S. Supreme Court is considering the question of whether sex in the 1964 Civil Rights Act, known as Title VII, whether sex covers gender identity and sexual orientation. So that's the question before the court. Now, there are a number of people in the world who have sincerely held beliefs around the binary nature of men and women. And this would include that there is only men and there are only women, and it is based solely on, the doctor's glance between your legs when you were first born, and that only men should be engaged in romantic, emotional, and sexual relationships with the opposite sex, so women. And they hold these are sincerely held beliefs, and they might be religious, they might not. In their minds, people who deviate from that traditional standard have, if not criminal behavior, at least they believe that they have mental health issues, and that various types of therapies, often known as conversion therapy, will bring those people back in line with their idea of what a traditional man or traditional woman is. And that's really what's behind any opposition. And what they want to do is scare you into believing the same thing they do, or short of believing in the same way that they do, at least believing the same way in regards to laws and regulations around businesses. So Title VII in particular applies to employment, all right? And so the question is, should a business be able to think, to presume, to assume that their clients are going to have an issue with somebody who is client-facing or not, but particularly they're talking about client-facing employees, and that if somebody is transgender or if they are too effeminate or too masculine, that this will somehow turn off customers, and therefore a business should be able to fire employees who do not fit, that traditional, what is a man, what is a woman, and only what your birth certificate said originally, and all of that kind of thinking. And the idea that somehow they should be able to fire people because the employee will now scare away customers or not make customers comfortable. The 1964 Civil Rights Act partly was designed to combat that exact thing, because there were still people in this country, and there still are, who didn't like to be in the same space with people whose skin color was different. And so they wanted to have separate bathrooms, and they wanted to have separate places where you ate, and they wanted to have separate water fountains. And the idea being that that a business could discriminate against people based on the color of their skin because it might scare away other customers. But that's what the 1964 Civil Rights Act was. One of the main purposes was to end those Jim Crow laws. And this idea that somehow you could discriminate because you think your customers are not going to like it. Anyway, same story here. Should a business be able to discriminate because they think their customers are somehow going to be uncomfortable with somebody who is transgender or who's too feminine or too masculine? And that's the question today for Minute for Equality in the Car. My belief? No. You should not be able to do that. Society is going to be okay, and your customers will be okay. I hope you like this video. Join me next week for another. We'll talk about privacy issues. Have a great weekend, equals. Bye.